Well, good evening, everyone. I'm glad to see some of you here. It is an odd time for me to come on, so I'm glad a few of you are here to talk. What I wanted to go over actually today, Bryan Kohberger just had another hearing on the 26th. And right now, hello, Peter Hutchins. I have to put that up because you cracked me up. Hosted by Claire, I ain't no lawyer bear. And it's true, I'm not no lawyer, but I do love this legal shenanigans that's going on. And actually, the reason I wanted to talk about Bryan Kohberger's case today is because what went on in the courtroom was quite intriguing. And it brings up some issues about the way things are handled in the state of Idaho in regards to their grand jury and how things go. And it was very, very interesting. Like, hopefully, could someone just let me know if my volume is good? I want to make sure that you don't hear anything in the background or anything like that, just if it's coming through clear. I don't see a mod yet, so if somebody, any of you, could just give me a little heads up. I see that little bee battle there, Mousy. Very cool. Yeah. And thank and hello to April and Beck and Mousy Files and Karen. It's good to see you. And Pete, it's not Murdoch, so I'm surprised, but I'm always happy to see you. Well, thank you, Juju. Thank you. Thank you, Mousy. Volume is better. Okay, thank you. Okay, all good. All right. I wanted to wait till through. Yeah, it's hard to hear through your own headphones, how it's coming through on YouTube. And you guys are the ones that matter, because if it's painful or too loud or too soft, it's a problem. So anyway, let's get on with Kohberger because, as I say, to me, this is legally interesting. And I was hoping to bring the conversation to you guys too. Hello, Recker. Nice to see you. I hope you're having a good day. The the issues that came up with Bryan Kohberger, first of all, I want to tell you that today is a year, 10 months, and not a year, 10 months. I'm sorry, not 12 months. I misspoke. Pull that back. 10 months, okay, since Kohberger's been arrested and everything's been going on. It's gonna be a year in a couple of weeks since the murders occurred. Well, the trial has not happened yet, of course. All right. But they're gearing up for it. Now, on October 26th, just this past Thursday, we had a closed door hearing and an open hearing, but it wasn't recorded and it was released after. Okay. And several things happened. But let's just get up to date a little bit on Bryan Kohberger. Remember, first degree murder and burglary charges for him. He was extradited from Pennsylvania, where he was at his parents' home. These were the 4 Idaho University students. Prosecution has still got the death penalty on the table, and that's important because it does have a lot to do with his decision not to go for a speedy trial. We were scheduled to have a trial this month of October, but we did not because he withdrew his request for a speedy trial and wanted more time based on the fact that the death penalty is on the table. That's a very good reason to pull back and get everything in line. Get your ducks in a row, so to speak. It's a different kind of defense. Of course, it's much, much more serious. Okay. There's been a gag order currently in place. And it does not gag the family, but it does gag every single law enforcement or anyone involved with the case intimately. And when I say intimately, I mean the witnesses, the attorneys, okay, anyone involved in that, everybody involved in the justice system, investigators, expert witnesses, regular witnesses, anyone subpoenaed to have anything to do with this case is gagged. Okay. Bryan Kohberger cannot talk about it. His attorneys cannot talk about it. The prosecution cannot talk about it. Okay. That part is gagged. All right. This hearing that happened on October 26th, part of it was closed behind doors. And that is because there was a motion filed that I told you about a couple of weeks ago. It actually happened several months ago, by Ann Taylor in the defense team, who there are another name, Jay Longston, you're going to hear about today, that filed based on improprieties in the actual filing of the indictment, that there was some errors made, legal errors, things that could get tossed. So that all happened behind closed doors because it had to do with the grand jury indictment. There was a grand jury held instead of a preliminary hearing. Okay. And then there's always some question in regards to that. Now, a lot of you that follow me, you hear me talk about this all the time. You can have one or the other. They either grand jury indict or they go for the preliminary hearing. In both ways, they are required to present some type of evidence or a partial of their case, and so that there would be reason to go forward for a trial. It is the process that happens to make sure that a trial is necessary, and that the expense of getting a jury and doing all of that is warranted. Okay. And here's where the problem goes. So not only did they say that there was legal issue in regards to how that grand jury was done in the closing arguments, in the rest of it, first I'd like to, again, with our victims, I always want to show the victims, and we'll come back to them again. But right now, I want to say that that motion that they filed, that they were handling on this thing, is not only was there an error in actual the indictment itself, but actually in the jury instructions that were given. Probable cause versus reasonable doubt, which is the interesting part I want to get into after. But they also accused prosecution of insufficient evidence, and that perhaps there was grand jury bias going on. And that grand jury bias part is probably very much part of the closed door session that was happening. But afterwards, there was an open session to where the argument continued. Now, whatever the errors that they went through, and they listed quite a few of them, and then it was sealed, because here's the thing: when it has to do with the grand jury, it is a very private and secretive tape, like, behind the doors thing. You don't get to know who they are. You don't get to know what's going on. It is protected. It is the process. And it's by law, it is not to be discussed in open court. And all of this was done behind closed doors because of that. Okay, so if they're going to say grand jury bias, they did argue that with the judge in a closed session. Okay. If they're going to say that the prosecution made errors in some of their claims in the indictment, that was done because of the grand jury, that was done in a closed session. Okay. But what Judge John Judge did was he did actually record some of it, especially the arguments that happened in regard. When I say arguments, I mean them presenting their case. The defense wanted to argue that prosecution put forward probable cause as the jury instructions instead of reasonable doubt. And it is a bone of contention that goes on in the state of Idaho. Probable cause is used a lot. It goes back and forth. There's been some stuff in California. It might be a little bit different. The argument was, as the judge had stated, a long walk through history, and he thanked the defense attorney, Jay Logston, for it. It was very interesting to hear it all. And I do have videos linked in the description that will show you the arguments that went on. It shows you Langston's point of view and what he said. It's a lot of rambling about the history, but basically they have a point in the difference. And you can understand if you're a defense attorney or someone going on trial for murder with the death penalty on the table, how the difference between probable cause and reasonable doubt would be very important to you. Okay, now let's go over some of that. Okay, this is, oh, by the way, meet Jay Logston. This is from the defense team, another person on the defense team, and he did most of the argument in regards to the motion to dismiss based on, basically, they're just saying erroneous grand jury stuff at all. They just think they wanted the whole case thrown out because they don't think it was presented to the jury properly. They don't think that they used the right instructions to the jury, and they think the jury was biased and used insufficient evidence. So, there's much more going on. Okay, so he was very well spoken. It was the first time I've heard him speak in court. Usually it's Ann Taylor who takes care of the court hearings. We've heard from her a lot, and she does a lot of the filings. But Jay handled this. And I have to say, I was quite impressed with this history lesson. It's worth a listen to. I think it's the second link. If you have the time, if you are a member and in the Discord, it's also in the Moscow trial room. A link to the video is there also. I think it's definitely, to watch his style is definitely worth it. Well, basically, we want to just discuss, though, what is the actual difference between the probable cause and reasonable doubt, and why is it so important, and how could they use it to actually throw this out? And it's because probable cause is when you have reasonable, trustworthy information sufficient to warrant a reasonable person to believe a particular person, aka Kohberger, has committed or is committing an offense. Okay, so in other words, you're pretty sure that there's enough there to link him to it. Not that a crime was committed, but that he may have committed it. Okay, and then beyond reasonable doubt states there is no other reasonable explanation that can come from the evidence presented. In other words, the jury has to virtually be certain of the person that they put up's guilt. In other words, like hands down. Now, this is grand jury, which means an indictment just to see if there's a trial. So they don't get to say if he's guilty or not. They're just supposed to weigh in on the evidence. Is there enough for this to be sent to another jury to decide? Which is why the probable cause definition gets used a lot by prosecution when they bring things to the grand jury. Okay. But the argument was sound by other states and other history where they were starting to use reasonable doubt to prevent wrongful convictions. And it became quite the conversation, which is why we're talking about it. I can't weigh in either way. I understand that that the families, of course, want a trial. And if they think that Kohberg might have had anything to do with it, they want it in front of a jury and let him defend himself. Let him defend himself against it. Okay, but basically the grand jury process was in whether or not it would go to trial. He could be indicted and charged and brought to trial, and they could put a case against him to a jury that he would have to defend himself against. Now, the grand jury decided there was enough there, and so there will be a trial. The other way was that they could have just did a preliminary hearing, and then in the courtroom, the prosecution pretty much laid out their case, and a judge would have decided. It could be either a judge or a jury could decide whether there was probable cause enough, enough there to move forward for a trial. There's two ways to do it. They chose to do the grand jury route. And some people, a lot of the questions that I get, and I'm not a lawyer, but I did research it for you. I did get several people in my DMs asking me, well, why did they do a grand jury indictment in the first place? Why didn't they just do a preliminary hearing? He wanted a speedy trial. He was opting out. They could have did the preliminary, laid out the case. We would have had a trial after that. The same thing we did with several other cases that we've watched. One of the reasons is the notoriety of the case, the media. Well, one of the reasons that you might want to actually do this is definitely the media. Okay. Because it is a all eyes on it kind of case. They wanted less out there. Okay. Another reason, the gag order. Already the media was on fire with information. Families were upset. There was stuff going on. People were being harassed, And so a grand jury in regards to looking at the evidence was probably best than laying the whole case out in an open court for everyone to see before trial. It would have been insightful. It could have been harmful to the case. It could have also been a little disrespectful to the families. I feel for the families the most right now. I do. I really do, because it's now almost a year. We don't have a trial yet. We will soon. We have no date. I have no dates after this court hearing on the 26th. All I know is there will be a trial because Judge did. Judge John Judge, he did dismiss their motion to actually dismiss the case. He denied the motion to dismiss. He said that there wasn't enough there in the argument. Um, Logsdon went very long. He also argued for the standard of proof to be raised to beyond a reasonable doubt instead of Idaho's usual sufficient probable cause at the grand jury level. And this is a very specific part of it. Now, probable cause is definite reason for an investigation. It's definitely a reason for subpoenas and to bring people in for interviews. It's definitely to check things out. Okay. Probable cause is absolutely how law enforcement works all the time. Okay. And so that's a standard. But what Logston's saying is when it gets serious to a grand jury, when you're talking about a death penalty case or something as serious as this, that you should have to provide more evidence and there should be less doubt before you go forward. And that is an actual, something that's going to be talked about between lawyers and judges and statesmen, legislators for a bit in Idaho, because although the judge said that the argument itself was very creative and he appreciated the walk down history, he appreciated the history lesson, he is actually bound by law. And there's nothing he can do to change law in this trial. He cannot change law. He is bound by law to honor the law during these proceedings. And the law says probable cause in Idaho is cool. And that is why we have a trial here. So as much as he didn't think there was enough there, he did appreciate the creativity. He did listen to them and, but basically all the prosecution had to do was stand up and say, Judge, the law states that probable cause was enough. That's what the jury instruction was. There is no error there. There is no prejudice against the defendant in using the law appropriately. And, he had a point, and the judge agreed. And it was very simple. The prosecution's part of the argument was very short. Very short. The whole actual argument that I saw the rest of the trial that was open was like 40 minutes, which is about average for arguments back, but with the prosecution not making any real argument, the that means that Langston talked a lot, and he did. And it was like I do recommend that you watch it because it was quite interesting, at least to me. And if you're a nerdy like me and you're into that kind of thing, I think you'll enjoy it. The other part of the case that was addressed was cameras. And now we heard those arguments last month. Those were not presented in court, but the judge's determination was. This hearing, he was just going to lay out his ruling on it. He had already heard the arguments of both the prosecution and the defense. And I want to remind you that both the prosecution and the defense were actually arguing not to have cameras in the courtroom. They were on the same side. It was the families and the media that are petitioning for the cameras. And this was the judge's ruling. He said there will be cameras, but it could be like it was on Thursday. The film was not released until after it had been reviewed that nothing violating grand jury protection was going to be released. He did say that there would be cameras, but he would have tighter control on what that process would be. And yet there was no actual listing yet that I saw, and I'm still looking, and I will present it to you when we get it, about how he actually intends to do that and what that actually means. It just means that we will have a peek into what goes on in the Kohberger trial when it happens. Okay. Let's just see. Okay. All right. I'm just going to pull this up and then I'll go back to the presentation in a second. I want to check your comments because I want this to be a discussion. Okay. First of all, hi, Shill. Shill, thank you so much for gifting memberships. Varillion, always grateful. Teresa, KCG, You have all been gifted, and Mrs. Cassandra have all been gifted memberships. Thank you very much for your support, Autistic Shield. I appreciate it. I really do. I like the new name is very long though. Husky Flus Investigations, aka you don't mind if I still call you Shill, right? Yep. Juju says, I am so intrigued by this trial. I want to see the evidence. I do too, because we haven't seen very much. I'm with you on that. I know, Pete, I hear you. There doesn't seem to be a motive. I mean, one thing I think we can all agree on, what we saw in the evidence and what we have heard in the indictment, uh, the motive is very sketch. Okay, I don't see one, but I'm hoping the prosecution brings that forward when they do. If it was beyond a reasonable doubt for the grand jury, then it would be a trial. If it was beyond reasonable doubt, in other words, they had to see something, but then you're asking the grand jury to determine if somebody's guilty or not before a trial. And legally, the legal scholars are saying, is that actually appropriate? I mean, we understand we don't want to put resources in. We don't want innocent people prosecuted. I get all of that. But if you're asking them beyond a reasonable doubt to decide, oh, hands down, let's just give it, then why are we even having a trial if the grand jury can do that? Why are we having another trial? The other side of the coin, so to speak. Hello, Sue. Thanks for joining us. Hi, Mrs. Cassandra. Thank you for the otters. Oh my gosh, that's so nice, all those otters. I needed otters today. Thank you. Oh, God. I do feel for the families. All right. I wonder why they went to the grand jury route. So they didn't have to release any evidence in the preliminary hearing. Exactly, Juju. That's what I was speaking on. And Juju, I do have a few things. Okay. For those of you that want to have information like that, I've got some little gifts for you in the way of links. Okay. One of them is right to the Idaho site, and there's the grand jury handbook there, so you can see like what they were responsible for actually doing, and it says about it. And the other one is on a law review and says, why would they go to the grand jury instead of a preliminary hearing? Your answers are all in there. But for this particular case, I do believe that it was based on what I have read. The determination was made because of the it was such a polarizing case. They didn't want the evidence out there. They already were looking at gag orders and a media frenzy. And I do believe that that's why they went to the grand, that they went that way. Also, it's very serious when it is involved with the death penalty. Yeah. So those two, besides the links that I left you about the actual trial hearing, the hearing itself, which A likes in speaking to Judge John Judge and laying out his a case on it. Well, how do you guys feel about the cameras? I was of two minds about it. I think you all have heard me speak that I think the media has been really interfering, and that I do understand that the families deserve a voice. And yes, they do. And there is a process to do that. What I have heard the other side of the topic. I mean, we see a lot of media coverage on the families speaking about we think this and we're not getting information. Basically, it's only from one area of the families. Many of the families are actually following the right and making appointments with the prosecutor's office and getting their answers. The problem is that a certain faction of the family only wanted the lawyer to deal with it, and lawyers are gagged. So, like, they can't. Like, now the family could go in there, but the lawyer cannot. Okay. So, it's just like a bone of contention. It can look one way if you look at it, but when you take the whole picture, when I take the whole picture into consideration, I really think the judge is making the right decision by allowing the cameras, but keeping total control of it. The family really wants them in there. They want full transparency. That's all we hear from the family. We want transparency. We want information. They were against the gag order. And yet, there are also large portions of the family and friends are being harassed. and they wanted the gag order so there would be less information out there to get harassed. Releasing the names of witnesses and people that are involved in the case can lead to other people just being idiots about it, looking up information on them, posting on their socials, uh, talking to them when they're getting their coffee. People just don't think about the space that should be allowed everyone to heal. Um, it got to be a bit of a bone of contention. Yeah. I think it is more for Kohberger to have the cameras in them. I think it is more fair. Can you expand on that for me? Because Kohberger's team, and I'm asking you to just for the other side of the coin, because Kohberger's team is totally against it because they say by having it in there, Kohberger already is the victim of so much piling on from the media and people making assumptions and everything about him. And they actually mentioned all of the body, the analyzing of his body movements, his body language and everything like that. There's videos out there. There was one already on this trial about the judge, the lawyer in Kohberger. I mean, just looking at it from that way. And I guess that's interesting to some people. Well, it can be very damaging as far as like whatever they say, and it's out there to the public. We don't have a jury yet. So we don't know who's watching what and who's gathering what information and who's going to be sitting in those chairs. And so the more that's done like that, the more information that gets out there, the more that it can be damaging to the defendant because people form an opinion, you know. You know what, Pete? I hope the trial will be delayed in filming. Show it later in the day. I do believe that part of his intention is to screen what happens and then release it later. Even if we have the court proceedings one day and then it gets released the next day, and we can actually do it, it would be just as beneficial to us to watch it a day later, knowing that there wasn't anything in there that compromised anybody in any way or was overly damaging. This way sidebars don't get overheard, jury's faces don't get shown, things that are supposed to be gagged, gated, or sealed will not be inadvertently exposed, like we've seen in other trials where the media actually try to zone in on the attorney screens. Come on, like they really were. I mean, the media themselves have made it quite difficult to have an open by their conduct to have an open courtroom. So that saying, a couple bad apples, right? A couple bad apples can seriously damage what happens here. But at least they're being, they're actually thinking it through. I think this judge made a reasonable ruling on that. And it was the one that we actually spoke about a few weeks ago. I think some of us were, I think, Pete, you may even have been here for that. Juju, I know you were. And we all spoke in regards to just reasonable, not completely open, Mhm. That is exactly why I think that Kohlberg has been piled on and convicted by media and channels alike. Yep. hmm Remember him having a bad jailhouse shave? Right, because of the scratch? Exactly. And now they're talking about how he doesn't talk in court. That's respectful. I mean, I wouldn't be talking in court. And now they're all like making these big comments about how he's so silent in court and he just lets his lawyers do their thing. I'm paying them money to save my life. Damn straight, I'm going to be quiet and let them do their thing. They, People are like crazy. Oh. If he is found not guilty, then I believe it is better for the public to see the trial and see why. Exactly. And I think that is along the lines of reasonableness that the judge is actually doing. He's got to weigh both sides of it. And in fairness, it could be guilty or not guilty. And the people, the public themselves are going to want answers. And the families themselves deserve answers. They deserve to see it played out, you know, and they deserve to everybody to know. Okay. His life is ruined either way, but the public at large can watch and say the jury got it right. It isn't much, but it is better than everyone believing the false reports. Exactly, because we have seen in trials, some of you have followed other trials with me, and we have watched a jury trial. We have heard the prosecution and defense, and then we see the media pick only one side and report only on that. Whatever was most salacious. They don't talk about the good moves that were made by either side during the day. They don't talk about the balance. They skip like the whole day and focus on one thing. Usually the most popular, the most salacious, even salacious, or controversial thing. Okay. We had a whole day of evidence and witnesses and statements made in Letitia Stott's trial. And on one day, they ignored 8 hours worth of court just to report on the fact that she was giving the middle finger to somebody. And it went on for days. And nothing else that happened in court that day got reported on. And I found that to be, you know what I mean? Like crazy, a little bit, It's not why I'm. Yep. That's the unfortunate part for all criminal defendants, Juju. His life is ruined either way, but the public at large can watch and say the jury got it right. Exactly. I did already read that, but I wanted to explain again, about everyone who gets charged for a crime and then it's in the media like this until it out. And that's why there are some crimes that I believe that should not be publicized until after verdicts. On then I think, either way it should go. People lives just absolutely get ruined with the charges. Now, some of them use that as the argument for grand jury for reasonable doubt and probable cause because of the ruining of lives, I do hope that we are going to have a trial in 2023. Although, because we just did the motion to dismiss to be canceled and we do not have the end of discovery date issued down there. We had the old ones, but then he went from speedy trial to a length of time. I think it's doubtful. I do think it's more like spring of 2024 at the earliest. But I could be wrong. I definitely could be wrong. Or no, says Clearview. I know. I said I'm thinking that. Yeah, see, now you're writing this in the chat and I'm just reading it, but it's like you read my mind before I even got there. Okay. Exactly. Mrs. Cassandra, this is what gets me. Besides all of it's another one of those where they're using, the data from the car. They're using, it's a lot of circumstantial evidence. They're using cell phone pings, messaging habits. They're talking about his whereabouts on normal days. They've actually done a lot of investigation on where he was before and after the murders for quite detail. And a lot of that circumstantial evidence is what they're presenting, because what we have is one spot of blood on a knife sheath. And we have an eyewitness that saw someone that could or could not be him. Okay. She has not identified in any statement I saw that it was him, even after seeing pictures of him. And, we don't even know if they're going to be present at trial. They're no longer in the state based on harassment that they got. They're no longer in the state, which means they have to come into the state to testify. Okay. And here's the other shoe. No evidence that we have seen. They may be sitting on something, and this is true. And that's why we didn't get to know, because it's a grand jury. It was a grand jury hearing. And they decided to go ahead and have him indicted. So what did they see? What did they see? I don't know if it's blood or not. I thought it was a spot. I do believe somebody said it was a spot. Now, like, I'm assuming a blood spot, and I will definitely have to check that but they did actually cross it back. They first did it through a family tree, but then when they got Bryan Kohberger's DNA, they tested it to a statistical match of great probability, like way, 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 way up there, like no doubt. They have no doubt that the DNA they found, in whatever form it is, a sweat drop, a blood drop, whatever it is, the DNA they found is Bryan Kohberger's. That's what they're saying. We have a list of the things that they found in there, Pete Hudgens. We do have a list of things that they found in the apartment and that the results of the search of the car. And then it got sealed. So if they did test any spots or anything like that, we don't have those results. That is absolutely true. We do have that there were a couple of receipts. It was very clean. They didn't find anything like we would you would think there would be blood everywhere based on the scene. If you recall, there were pictures released about the scene, a picture of the outside of the house where blood was seeping out of the house from the floors. There was so much blood. And that it is reported to be a very bloody scene. Multiple stab wounds. Okay. And I would think you don't walk out of the place totally clean or into your car with nothing. But then again, stranger things have happened. Like this is what's so intriguing about this trial and why I think I am actually pleased that we will have some type of accurate transparency reporting with actual release of partial court, at least partial, if not more. Mousy says, I hope they do have some evidence that they were sitting on that was worth putting the parents through this trial and ruining a man's life. Yes, well, the parents, they want justice. That's for sure. All the parents want a trial and they want somebody held accountable, you know? And but yeah, I do hope there's more. I can't wait to hear more, you know. Or if there was more DNA on the sheet, they didn't have to list it all just enough to get the indictment. This is true. They only had to go with their preliminary findings. That's another very well made point, Juju, that we should bring up. That definitely they did not have to list anything else except for their preliminary findings if they felt it was enough. That was their decision, you know, to list it that, to only go forward with that. I mean, that's what they did. Yep, just evidence that they have. Exactly. Yeah, and Mousy, that's the other thing. They're going to bring in, like, that's going to be the part about motive that I need addressed very well in the court. Like, I want to see how the defense says that, that is such a physical act to do. Like, why would I do it? Like, I almost expect in every hearing for him to stand up and say, why would I do this? Like, um, because I don't really believe the theories. Now, some of them say because he was a crime student, he was he had a legal mind. He was absolutely interested in law enforcement, investigation work, all the techniques that are used in forensics. I mean, he's done the studies and the work, and he's a criminology student. But that doesn't mean that he wants to commit crimes. Yeah, stab wounds or you're right. It was horrible, Pete. I agree. I absolutely agree. To say it like, yeah, it could just be like a stab. No, this was an actual intent to kill and murder. Wasn't Doesn't look like it was an altercation. Look like there was any means of passion. They're saying it was he broke in, went to those rooms and killed them physically with a knife. Yeah, Juju, that's one of the things. Let me put this one up. Yeah, I don't buy that he was going for the perfect crime theory. True. I think there's also a theory out there that he was trying to prove corruption in Idaho's prosecution. that he was going to prove that, like, even if you have the evidence, like the way they would mess up the case, and that it was a vendetta against the other side into how they prosecute and not doing a good job. Um, there's all kinds of rumors and stuff out there. The Reddits are full of it. I think the thing that makes this the most fascinating is there is a reasonable chance he gets off. You know, Wrecker, you're saying what we're all thinking. Actually, and I hate to say that for the families because you want them to get justice. But when I look at just what they have right now, I have doubt. I do. But then again, I have to also say I don't have the whole picture yet, and we will not until we see the trial, until we get everything that's going to go in the trial. With the gag order in place, we don't even know what testing's been done. We don't know what further investigations has brought forward. Yep, exactly, Juju. I couldn't have said it better. From what we know, there sure is reasonable doubt. But I suspect we know very little of what they have. Yep. I say, hello, Paula. How are you? Yep, we need the whole picture, Pete. You know me, I'm a whole picture girl. Like, I want all of it. I want to see it all. Like, I have my feelings, about what's been done. I've been very, very terse in regards to the media's handling of it in the beginning. It was quite offensive to me. And I was like, oh my God, what are you doing? Like, I realize everybody is so emotional. It is horrible. We're talking about a university town with all these students, young people, beautiful, young people that didn't deserve this. And you know what? While we're talking, I would like to honor them, because in all of our media, we just need to do that more. Is to They're no longer here, and what we don't want to do is forget them. We have to remember this trial is for them to get their justice, and also the trial is for the accused to defend himself either way against the crime, to decide whether he is guilty or not. But we never want to forget who we're doing it for, not for Ethan, Madison, Zina, or Kaylee. you know they did. And then, Pete, it's horrible. And the families, this they have to deal with every day. And the longer the proceedings go on, the harder it is, for them, But I think the gag order, many of them are happy about the gag order because it has calmed things down somewhat, especially in the general area that they are. Because remember, these families, they all live there, people, they're running into people all the time. It's different if you're just trying to heal and everybody's just getting used to it, or you're dealing with an article that just came out that morning, or a news report, or a breaking news summary about this, that, or the other thing. you know at least they can actually try to get some normalcy in their days the best that they can, until actually they can go to court and see the trial. And I am hoping that it is at least in the beginning of the year. I do not think we'll be closing 2023 with it. Just based on now that they know the motion of dismiss has been tossed. That was like, I like to think of it as a Hail Mary. I think it was quite creative, as the judge said. I mean, he used a good word. It was very creative to go against the jury instruction, the grand jury instruction on that, picking up on a vibe of something that's going on all across our country, in federal courts all over, in many states, back and forth, and that there is a difference. But in Idaho, they have clear law into what is allowed. Yep. I liked it. I liked it. Mrs. Cassandra is thanking you all for being chill, and I have to say ditto. I really appreciate when you all are just so chill and talk about the case and everything. And it's just, for me, it's quite pleasing. And for my mods, it makes it very, very nice. I'm glad you're doing your duties there too, Mrs. Cassandra. And it's nice to have you here, and then you can listen. So there we go. All right. So questions in regards to the hearing. First of all, the information that I put down on you, sometimes it's like really legal, and and you don't actually you don't actually think there's anything to discuss. But if you want, I am more than willing to answer DMs about any part of it you have a question on. I'm not a lawyer, but I talked to a lot of them, and I can actually point you in the direction on somebody. The next link that I put was the actual order taking judicial notice of the grand jury record. Okay. Um, it's just a little bit of piece of information that kind of goes along with what they were doing, you know. But basically, the judge basically could not have ruled any other way than he did in regards to the grand jury, unless he saw the prosecution making something like an outright false statement. I don't think he could have canceled any of this because there is law and precedent already there in Idaho. Okay. He also said that everything had to be kept quiet because law specifically in Idaho details that grand juries are secret. The arguments about the legal standard used were held in open court because they didn't involve the jury, okay, and the proceeding was already done. They were just arguing about why a use of terms. So there was no danger there of exposing the grand jury or the process, okay. But in Idaho, they used probable cause, as was put forward, okay. But Mr. Logston, Jay Logston said that, he they really should have used reasonable doubt because it's a higher bar to clear. And they were talking about a man's life here and the seriousness of the claim. Okay. But probable cause, like we talked about, that's enough evidence or grounds to show that a charge is well founded. So, this legal argument back and forth in regards to the use of language and the standard, okay, it's pretty dicey because reasonable doubt means that a reasonable person has seen enough evidence and proves that they believe beyond a reasonable doubt that the crime was committed by the person they're putting forward, the defendant. And to me, I don't know about you guys, but in layperson's term, doesn't that mean like trial jury, like guilty, not guilty, verdict? Um, no. I do think probable cause is probably the way to go for indictments, but I'm not a lawyer. Okay. Idaho legislators set a higher standard for grand jury indictments, but the Idaho Supreme Court lowered it. Okay. So some people tried to push it forward to the higher standard of reasonable doubt in Idaho. And when it went to the Supreme Court, they brought it back down because they're talking about the Fourth Amendment here. Okay. Ability to face your accusers, blah, 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 blah. All right. But it's going to keep going back and forth. But I think it was very clever of the defense. I really do. To pick up on this argument within Idaho itself to try to get the whole thing tossed. Now, the judge also did say that I am bound by law here. It already went to the Supreme Court. However, you may bring it to a higher court. You can bring this to a higher court. I just can't help you. I think it's creative. I think it's a great history lesson for everybody. However, I am bound by here because the Supreme Court brought it back down because they never tested it constitutionally on its own rule. It was never challenged. Okay. And get ready because I think that's going to happen in Idaho. I really do. Okay. So it was not Bill Thompson who actually spoke for the prosecutors during this hearing. It was actually the Deputy Attorney General, Jeff Nye, who was assisting, of course, in the prosecution. He countered that the Supreme Court ruled on the issue multiple times and that they repeatedly upheld probable cause standard and that burden has been met. And since that is the current law and state of procedure, that's how it was done. Why would they do it any other? And why should their proceedings be tossed if it is a matter of settled law? Now that term, I mean, I actually kind of giggle at that term, settled law. Is there really any settled law? Anything can be brought back up to the Supreme Court, and you can do it multiple times. There's a whole process on, well, you say it's settled, but then again, I didn't like how you settled it, so here I go. I'm just saying, the fact that they're saying it's settled law was a little amusing to me. And Even though the judge used the same term, it's settled law as far as I'm concerned, because that was the law right now, and that's what I have to obey. It's interesting that you're bringing it back up. It's quite creative, but I can't help you. And he's kicking it back, like, if they're going to do anything about it. But he did rule that he would not toss the case, which means he made a judgment. So he didn't wait for them to go anywhere else with this. That'll be up to them. And we'll see if anything gets stayed, but I doubt it. But I'm thinking there's more of a conversation here to be had. But the defense, everyone who weighed in on this when the motion was filed, said it was a last ditch effort, and it was very unlikely to be successful. Extremely unlikely. If you remember, Kohberger had his not guilty plea entered by the judge earlier in the year. Okay. And the Latah County prosecutor, that's Bill Thompson, the guy with the big beard, he said he still intends to seek the death penalty. So they're still waiving that. And when Kohberger waived his right to a speedy trial, the October 2nd date was removed, and no trial date has been set yet. There's not really much more that I can I'm just going to take questions. I'll go through the chat because there's not really much more. Wait, it was blank? Hold on, I'm looking. It's not blank for me, but I'll tell you what. Here's the article it comes from. If you, Juju and everyone in the chat, if you go to this article, in this article, a couple of paragraphs down, in the paragraph, oh gosh, 1, 2, 3, 4, 5, 6, 7, 8. In the 9th paragraph that starts in May, towards the end, underlined, it says 3-day process. There's a little blue envelope there. If you click on 3-day process, it should pick up a link to the document that is from the grand jury notice. And if not, like, there was not a lot of information. What I will do, if it still doesn't work for you, I will take pictures of it and reprocess it. No, I did just drop. This is the, oh, wow. Wait, why is this? Okay, hold on. Why is it doing that? I'm actually pulling up an article. All right, hold on. I see what you're saying. I don't know why it's doing that. Because I'm pulling the article from a search. I have no idea. Okay, I see what's going on. I'm gonna have, yeah, it's blank. It is blank because for some reason, when I go to the Lawton Constitution, it only comes up with this as a it's pulling they've got something attached to it that makes it go to my office stuff. I don't know why, because all the other articles are coming up fine. But I'll get it for you, and I will okay, hold on. I think I can do it as a little bit of a file. Hold on. All right. I got it. Hold on, wait a sec. I know. I have dead air now, and I'm doing the talk amongst yourself thing. Okay, let's go to All right. Oh, why is it? It's still not doing it. Okay. All right, try this. And if this doesn't work, I'm going to have to, I'll put it in the links after. Try this one. This is just not. I don't know. Yeah, I will fix that for you, Juju. I will get it in there. I will put it in the link. Well, let me just show you what it looks like. I can actually pull it up. Just so that you understand you're really not missing anything terribly. But we will do it. Okay, here it is. It is a PDF. What? Now the link is in pic. Okay, that's it. There's something going on with my system then. Okay. I don't know. I don't know. I'm going to show you, and then I'm going to put it back up. I had the same thing trying to use my pin today. Okay, so it is from prior. It's about the case. It's the order taking judicial notice to the grand jury. Okay, and about that it was like when the record was going to be processed. The electronic juror questionnaire was provided to the judge of the state prior to the grand jury proceeding to the case, and it's basically showing all of the documentation was synced. Because one of the things that they said is that no notice was actually given, and what they did is provide this to show that it was. They granted the court takes judicial notice of the grand jury record and case order. So in other words, they got the whole record provided back to the judge so that they could have this closed meeting. Okay, and they needed all of that to go through it. And the reason that I was sending it to you to show you, okay, when all of this grand jury was done, that they took the days that they did, okay, and that there's the transcripts, okay. They had 3 days to do it. There was all of that was transmitted, and it's all so private that they can't even release the transcripts or anything else involved in the case. That anything that he got, okay, from the grand jury, he had to hold and use in their arguments in closed session completely. It still was undetectable. Wow. Hold on. Let me just. This is weird. I don't know what to say about it, like except for that something very strange is going on because I have other articles up. I don't know why this one does it. Okay. Yeah, it's got to be that Counting Law site. It's got something attached to it because now, like, it just comes up like the Hearings Tribune and a couple of other places. They come up almost identical with the same article. Here. Oh, and that link is way too long. Yep. Okay, here we go. Nope, because every time you pull it up, it still comes up with the same thing. Wait. Here you go. I think I got it now. And once I get this link in, I think that's it. This is it. Like I might have to take the whole. All right, try this one. Somebody with a computer, try that link and tell me if that silly thing doesn't come up. All this for a 2-page listing of like nothing to read on the grand jury transcript. It really just shows that that they requested it and they got it for the actual well posted. Okay. Okay. And so you see how silly, like it's just basically only shows, you know. Yeah. But hello, Elliot. Okay. All right. There you go. All right. So I'm gonna look and see if there's any other questions. All right, there you go. All right. So basically, all secret. But anyway, so basically, that was it for the hearing. And we're going to wait on trial dates. Okay. The next, I guess that's going to wrap it up. I'll just give you a little bit of channel news if there's no more questions. Tomorrow we're going to do Halloween crimes at 9 o'clock. And then I do have quite a few other cases. There's some movement on the Boone case. There's something on Stephen Smith. The SBF FTX trial is well underway, and Samuel Bankman Fried took the stand, and I would like to talk about that also. So I'm thinking Friday, but not as late. You guys in the chat, are you all late? Are you all prefer late, or is earlier around dinner time a little bit better? Uh, mm, I don't know. You can always DM me with preference times too. I'm always putting up polls on the community tab, trying to find the best time, and I do like to put them at different times for different people to be able to come. So. Mm. What happened to who, Elliot? Let me see who that. uh, Lost Souls? Hmm. I could look into it, but I'm not familiar. I'm not familiar. Well, is that a case that you are following? Mm-hmm. I usually do go around 9 o'clock then. I think I'm going to wrap it up. We can also, you can add comments on the back of the video if there's a time that you prefer. But since we got, it's just another channel, I recognize some of the names in here from. Not trying to promote another channel, just never heard from them in a while. I'm not familiar with it, but I hope that somebody can get you an answer. Like I'm not sure. I'm not familiar with the channel. Um, and I don't mind that you mention another channel. It's okay. You know, if you recognize people here, I'm glad if you can get an answer. Actually, no problem at all. But on that, I think we did a little bit of channel business there. I didn't put my banner up at all. I'm going to put it up now. Like, can I believe I did not put the banner up at all? And I did so good yesterday, you know? Oh, well, thank you, Elliot. And I appreciate that. Welcome to being a subscriber, you know? I'm going to try to have a good night, Pete. Welcome aboard, Elliot. I will be back tomorrow at 9 o'clock with Halloween Crimes. We're going to discuss how we get the names of these stories, that go and that they do originate from original crimes. And some of them don't actually have anything to do with how the movies and everything else like kind of puts them out there. Well, thank you everybody for being here. Thank you for making my mods job so easy by being people that just want to have a conversation and enjoy themselves in the chat. I truly enjoy it. And I love talking with you all about it. Remember, if you have any other cases that you're interested in, things like that, my DMs are always open. All my contact information is in the description below, also on the about of my channel. Hopefully you'll see some of the other content I do on the weekend can be a little more towards the social medias and the craziness and funny of the stuff. And then on Sunday we do a stream about nothing, absolutely nothing. Um, but I am going to come back Wednesday also. I just don't know the time yet. And I hope you all have a great night. And I'll see you all tomorrow. If I don't see you, I hope you have a great night, and I'll see you during the week. And on that, I'm going to find me an outro, and then I'm going to be out. Have a good one, everyone.